with respect to that, I think that even if we had known about that record and had that record, we're going through hundreds of thousands of documents, trying to turn over every single thing that is potentially relevant. And frankly, I don't think there's any way that we would have anticipated that whether Mr. Bundy's cattle were or were not harming the desert tortoise habitat would have any relevance to any element of the offense, any possible defense to the charges charged in the superseding indictment. The only thing that report could be used for is to try to make an argument that the federal district orders that the law enforcement officers were executing were somehow invalid and should be ignored. And that, in our view, is simply an argument about jury nullification, and so we would not have believed that to be relevant in any event. But but we did look for it and we tried to find it. Now the talk log is the administrative log about the SWAT team. The FBI was at Bunkerville for 4 days. They were there from April 5th until the 8th. I think they kind of left the SWAT teams in the pre-dawn hours of the night. So they were gone before Ryan Payne arrived in Nevada. They were gone before the incident, the actual standoff and assault on April 12th. And so the way it was explained is that the administrative log, which is sort of tracks who's where and what they're doing, because the SWAT team was never activated, that file was never put into the investigative file or the police assist file because it was just this administrative log.
Yeah, and it's that
I'm sorry?
that uses the word snipers that's not elsewhere in the record, correct?
There is 2 points. Yes, that the talk log does have 2 references, snipers inserted. Apparently they went on some sort of training mission while they were in the area. But it is not true that there was no discussion about snipers elsewhere. There was a significant amount of information that we disclosed, primarily about snipers in the wash, law enforcement officers taking marksman positions.
Was the word sniper used in those other documents?
Yes, absolutely. We in our opening brief, we included some of them. I think that one of the things that I pointed out is that we had a park ranger who testified at the first trial, and he testified that he deployed his designated marksman team, and he described the designated marksman team. One of them's got a .308 long-range rifle with a scope. The other one has binoculars to work as a spotter. And then on cross-examination, he was asked, so a designated marksman team, that's like the sniper team, right? And he said, yes, it is. And they said, and is your team in this picture here? And he said, no, they'd already been deployed. So this idea, and this is one of the things that the judge said in her order, that we had insisted in prior trials that there were no snipers. And in fact, there was discussion, the discussion about snipers focused on 2 things. The officers, the BLM Rangers, Brunk and Russell, who were on the hill above Dave Bundy when Dave Bundy was arrested. The defendants wanted to call them snipers. They were not snipers. They were BLM officers carrying BLM issue rifles. They were not sniper rifles. They were not hidden. They were not camouflaged. They were not trying to shoot people. They were there in Overwatch. So there was discussion about the use of the word snipers to describe Brunk and Russell. And there was discussion about, on the 12th, at the actual standoff at the watch, whether the officers who were up on the mesa were snipers. And they weren't. But there was discussion about that, and we pushed back about that. And I think I want to step back and make one thing clear, because the defendants were arguing, and the judge in her order really does sort of seem to accept this idea that the government was playing some kind of semantic word game with the word sniper. That, we should have known that they were just talking about officers with guns, and we should have accepted their characterization of snipers. And I would just point you to 2 motions that Ryan Payne includes in his excerpts of record. There were 2 motions that were filed by the co-defendants in the earlier trial. And it was a motion in limine to try to preclude the government from referring to the gunmen on the bridge as snipers. And what they said is that the word sniper is an inflammatory word that carries a horrible connotation. That a sniper is the most hated kind of soldier, who is camouflaged, who hides where he can't be seen, whose mission is to shoot to kill, and who paralyzes people with fear. And so the defendants were saying, so don't call us snipers, because if you use the word sniper, that's the connotation that you're sending. That's the message that you're trying to send about who we are and what we do. And so I would say that, you know, these defendants, and we didn't refer to them as snipers.
Okay, I'm sorry, counsel. I'm sorry. Just need clarification. So that motion to eliminate was filed in the first trial.
Yes, they filed it in the first trial, and then they filed it again prior to the second trial.
And it was filed. And who filed it? Mr. Payne.
It was the trial 1 and trial 2 co-defendants. I pointed out because Ryan Payne included it in his supplemental excerpt of record in this appeal, and so I think that, but I think that it characterizes.
I'm sorry. Who filed it? Did the public defender file it?
No. Public defender is representing Ryan Payne.
In this case, so this is somebody else in the first case. There's not the government who filed this. No. This was the defendants in the first 2 trials. A motion to eliminate to preclude the government from referring to the defendants on the bridge as snipers. And Ryan Payne included that in his excerpt of record on this appeal. And I think that the importance of it to me is that it really does explain that a sniper means something. When Ryan Bundy, or when the Bundys and Payne sent out the word that Bundy Ranch was surrounded by snipers. Okay, so counsel, I'm going to push back just a little bit here. So you have a number of paragraphs in the indictment, paragraphs, I think it's 84, 88, maybe 92, yes, that claim that Cliven Bundy and his sons and others deliberately distributed misinformation about being surrounded, being surveilled, and that there were snipers. So there's sort of 3 things. Yes. The word snipers does appear in the indictment. Now, yes, if the tactic in the first trial was to somehow get the word sniper out of that because they thought it had a bad connotation, why would the defendants in the second trial be bound by that? They filed a motion to eliminate to exclude that. I mean, this feels like a different strategy here, and it feels like it's probably a legitimate one. That is, you've alleged that Bundy falsely claimed that there are snipers, and yet there are FBI documents and other documents in which they themselves use the word sniper, and that would mean then that those allegations, you could not prove those. Yeah, and I think, and this is where we were on November 8th. On November 8th, so we had turned over information, the organization chart showing who the BLM folks were that were going to be doing surveillance around Bundy Ranch, the operation plan that said that Bundy Ranch was going to be surveilled 24/7, and that the teams were going to be armed with, were going to be carrying agency rifles. We had provided that information in a number of different forms. And as I say, I mean, the Racker 302 and the Del Molino 302, we missed those. We turned over 400 some 302s, and we missed those. And it was on November 8th, and it was actually talking about the surveillance camera, hearing about the camera, where the defendant said, you know, this isn't just about provocation, because they had been talking about self-defense and provocation, instigation, and they said this isn't just about provocation, instigation. This is, I mean, the government is alleging that we falsely said we were surrounded by snipers. And if we actually believed that we were surrounded by snipers, if we mistook the surveillance camera, or the BLM officers in the lookout point, or the technician who came to service the camera after Ryan Bundy ran it over on his ATV, if we perceived those to be snipers, then this actually goes to a way that we can rebut the specific allegations in the indictment. And what the district court said, this was a hearing about the surveillance camera, what the district court said is, okay, I see. Now, Judge Lean had denied your request for information about the surveillance camera before, because
You made no showing of materiality, and there was no apparent materiality, and so I find that the government didn't do anything wrong. There was no bad faith here. But now that you're making this argument about mistaking these people for snipers as a way of saying subjectively you felt like there were snipers, whether there actually were or not, you can use this to rebut these allegations. Now I'm going to order the government to turn this stuff over because now I see it's material. And so we did. And in fact, with respect to the surveillance stuff, they were talking about stuff that we had disclosed the day before that hearing. So in fact, by the time, with respect to the camera, the government said that that she found that this new theory made it material, we had already disclosed it. I would like to save some time. I imagine I'm going to have some rebuttals. So if there are any other questions you want from me right now.
Let's hear from the other side, and then you save some time.
Thank you.
Your Honor, Larry Clayton, on behalf of Todd and Bundy, may it please the court. This case was not about an armed confrontation with land management officers or the FBI. If there was a confrontation, it was by these individuals, by these entities themselves, and that's important to remember. My client has already done nearly 2 years in prison, and he was even put in solitary confinement at one point. Now, what is absolutely correct that Ms. White stated is that there was flagrant abuse here, gross abuse. And we've seen that in a number of situations, and my colleague, Ms. Cleary, is going to get into it. And Judge Navarro made the exact correct decision. Now, what I had filed earlier, Your Honors, was a motion for limited remand. And you had the courtesy of telling me that I could raise this again in our initial brief, and I'm doing it at oral argument. The appeal should be summarily dismissed. I mean, it's not something, or rather the dismissal of the indictment should be affirmed. But if Your Honor has any issues here, the slam dunk will be the testimony of Larry Wooten, a BLM whistleblower who came forward and revealed things that are unimaginable. Kill lists on the heads of people, disparaging the Mormon faith of the Bundys, in effect calling them the equivalent of subhuman, people that were celebrating on our fucking heads. The Bundys having been assaulted by some of these federal agents. I can go on and on and on, and you'll see that, because not only was there a report filed at the court level, although we never had the opportunity to take the testimony of Larry Wooten before the indictment was dismissed, but I obtained Freedom of Information Act documents through a parallel case in Washington, D.C., which detailed the gross abuse here. And not just with regard to the agents, is that this whistleblower, Larry Wooten, who was a high-level supervisor, special agent on the case, came to the prosecution, came to the U.S. Attorney's Office, Stephen Myray, Daniel Sheese, Gloria Mudd, and said, look, this is what's going on. Exculpatory information is being withheld. This is the gross misconduct that has occurred. Even religious rights are being violated. And Myray and company turned a blind eye and instead recommended that this agent, Larry Wooten, should be taken off the case, retaliated against him. So, Your Honor, I do take slight issue with your saying this is not about the prosecutors. It is about the prosecutors. As a matter of fact, there's an OPR investigation, an IG investigation, that in theory is going on with the Justice Department as we speak. I'm not privy to the result because they don't give that to private individuals until they release anything. But there's one other fact which is very, very important, and not just with regard to snipers, is that among the information that was withheld were risk assessment reports which shows that the Bundys were not violent, they were peaceful. And that's super important for the jury to have heard that. Now, last but not least, what I'm saying is that affirm the dismissal, Your Honor, but if you're not going to do that without great thought, then we need to be able to go back and take the testimony of Wooten, put it on the record, because that would be the nail in the coffin of this prosecution.
Counsel, you're making that request because if you think if we were to reverse and send it back, the district court wouldn't do that on its own? Or I'm just confused as to why you think...
Well, I don't think that you should reverse, Your Honor, obviously. What I'm saying is that this is the insurance policy of my client to have you rule and affirm, because this is a matter that you should be able to see straight up. Now, you do have documentation. I provided it to you. And there is a report by Larry Wooten on the record, although it was not admitted into evidence. But there's absolutely no doubt, and I'm dealing with what Ms. White said, which was frankly untrue, that there is gross abuse here. There is gross abuse. It's one of the worst cases of abuse, I think, in the history of any prosecution. And one other point is that my client, Clive Bundy, and his sons were subject to entrapment. This U.S. Attorney's Office, the U.S. Attorney Bogdan, Myray, Peace, Ahmed, went out to the Bundy Ranch before any of this took place. And in fact, Larry Wooten says in reports, I've never seen this happen before, where the Justice Department is in fact orchestrating what is in effect an entrapment. The role of the BLM is to conduct the operation, not for the U.S. Attorney's Office to try to set the Bundys up. Now, Wooten, who's Mormon himself, was also disparaged in the course of this.
Counsel, can I just interrupt? I'm just confused as to why you're telling us all of this, because as I understand it, the Wooten materials or the Wooten allegations are not really before us. They are in the sense that you've made us aware of them, and they are deeply disturbing, I grant you that. But the district court didn't rely on them. If you were to affirm the district court's order, the Wooten allegations at that point are irrelevant, right, for our purpose.
You're absolutely right, Your Honor. I just want you to know that.
All I'm asking is that if we nonetheless were to reverse, why is it that you're telling us you have to order the district court? Because the district court wouldn't do that on its own. That's what I'm just confused about.
No, what I'm telling you is this, Your Honor, is that you should not reverse, and Ms. Cleary will get into that on behalf of the other defendants. But I'm telling you that even if you did, this case would be long since.
Okay. Any further questions from Mr. Clayman? Thank you very much.
Thank you for your courtesy, Your Honors.
Thank you. May it please the court, Amy Cleary on behalf of Ryan Payne, Ammon Bundy, and Ryan C. Bundy. The government has charged our clients with 16 very serious crimes, all of which hinged on the theory that they engaged through conspiracy or aiding and abetting to provoke a violent conflict, to harm federal officers or obstruct those officers. And it relied on a theory of false messaging. Yet the very evidence that the government withheld all ran to evidence that would have supported the defense that the defendants, our clients, did not engage in false messaging. That is why this is such an egregious case, and it's a troubling case, and it's a rare case, and it's a case that Judge Navarro below took very careful steps to give the government multiple opportunities to recognize that she was concerned about its discovery problems, gave the government multiple opportunities to come to her and say why these things were not disclosed earlier, to give the government multiple opportunities to provide additional briefing, to go and find this information, and to give other proffers to her. And what the court found was that repeatedly the government was not only past the discovery deadline, but past the trial deadline, and through trial, and even past the point that the mistrial was granted, that the government still was disclosing material Brady and Giglio evidence that ran to the heart of our client's defense and making material misrepresentations and proffers to the district court.
Counsel, can I ask you a question that's
certainly
on just one element of the analysis? Let's assume that we agree with you that the government did engage in flagrant misconduct here. So let's assume that the district court didn't clearly err in making that finding. Can you help me with the substantial prejudice problem? Maybe by identifying the one or two, just take the two best and strongest pieces of evidence that you were not provided and explain how that caused such prejudice that it could not be remedied through anything less than dismissal of the case with prejudice.
Certainly. And I'd like to address not just particularly the evidence, Your Honor, but I'd like to address the district court's finding that the government's case was faltering. And the district court here sat already through 2 failed trials and had been familiar with the evidence. It was familiar with that our clients were in a different position. These clients were not, quote, the gunmen that were charged in the other cases. So as the court sat through the trial thus far, it was receiving jury questions from the jurors. Now all of them were asked, but the jury questions already received by the district court in this case were indicating that the jury was reflecting, it was having serious questions with the 3.5 witnesses that the government had already produced. It was questioning the tactics that the BLM had used. Why was the BLM why had they not tried to use other tactics in approaching the impoundment? Why was the BLM or the FBI not being honest in its representations to Ryan Bundy in recording the calls? Was there really any injury to any of the livestock or the tortoises on the property? The jury, just in the 3.5 witnesses that were presented, was already questioning what the government was presenting. So the district court was already recognizing that the government, if it had a chance to redo its case, would not make those same mistakes again. So the prejudice thus far, one of the larger prejudices is the district court did not think it was appropriate to allow the government to get a, quote, do-over to correct those mistakes. That's one of them. The second is because the defense had to fight so hard to get all of this discovery evidence, because the government, in making these representations to the court, and in normal circumstances, the district court should be able to believe proffers from the government, granted. But in order for the defense to get the court to understand that the government was not being truthful, the defense had to reveal a lot of its defense strategy through its voir dire, through its opening statements, through its motions, how it would use that evidence. And by revealing all of that to the district court, not only did the government get all of that, it would use that now at a new trial.
Counsel, isn't that true in almost any case that comes up on appeal here and then gets reversed by this court for some kind of a trial error? I mean, at that point, the government will try to correct whatever mistakes it may have made, even mistakes that weren't appealable. The government thought, well, we could have done this better, and the defensive strategy will have been revealed. So why is that a problem? Because this happens all the time.
It conceivably could happen, but the substantial prejudice here is that when you combine all of that has gone on, for the government to be able to take advantage of those prejudices, on top of all of the misrepresentations, on top of the faltering case, on top of the fact that even if you did not believe that this raised the type of prejudice in one particular area, the prejudices here stretch all of the areas.
Can I just ask, though, in response to my earlier question, what I wanted you to do was to pick the strongest piece of evidence for you, right? The thing that you thought, boy, if we only had this when we should have gotten it before trial, sure, this is how things would have gone differently. Just walk me through a concrete example of that. And the reason I'm asking for that is that the district court substantial evidence findings were very general, and they were kind of boilerplate that she just repeated the same thing with respect to each category of evidence. So just help me with the specific one, whatever the strongest piece for you is.
I'll give the example of the camera, because the camera led all the way through the TOC log. When Ryan Bundy requested the camera evidence, the government called it a fantastical fishing expedition and told the magistrate judge that it wasn't material. Now, under Brady, we don't have to show materiality. The government has an obligation to produce it. Nonetheless, the government said it wasn't material. later on, through an evidentiary hearing that we had based on evidence that we discovered that there was shredding of documents, a witness testified that there was a camera with a live feed. That witness was the first inclination that there was a live feed of a camera. That information led the district court to say to the government, that's something that we would want more information of. Can you go back, government, and find more information? The government said, when that information came out, and I quote, "So what?" That was the government's first response. That surveillance camera is important for many reasons. That surveillance camera was, there was agents who were servicing the camera at night around the Bundy home in tactical gear, and that were part of the environment that the Bundys were, when they were expressing that they were fearful and that they were surrounded and that they felt that there were snipers around their home. That was part of that environment that they were expressing on social media, that they were afraid. Through further evidentiary hearings and through further court orders, after the government said nothing came of that camera, there was no recordings, the court said to the government, you don't just have a live feed with nothing taken of it. That's just not the way things work. And the government had to be pushed by the court to say, go back, government, go and find something, or at least give me a negative report that there wasn't something there. It was only then that the government said, okay, we'll go back. It was then that within a couple of days of being directed by the court to find this information, within a couple of days, the government found it from the FBI. It wasn't as if it was in a storage facility. That information was in the TOC file, the TOC log. Not only did the TOC log have the camera, contemporaneous notes from the camera, it had the sniper entries, it had contemporaneous information about what was going around, not just in the Mesa that the government would want you to have to leave. It had information about the camera. And the camera information and the information about these, what was going around about the Bundy Ranch, that's what's important. Yes, we had information about what was going on generally about the Mesa area, but it is information about what was going on around the Bundy Ranch, about the officers and their close proximity to the Bundy Ranch in tactical gear with rifles at night, and that the camera was really what was preserving and what was reflecting to the Bundys their surveillance during the day and why they felt enclosed and isolated during the day. And then the additional documents about them being within 600 feet at night, with rifles at night, with being surveilled at night. That was all part of the information that was necessary for our defendants to show that this was not false messaging, that when they provided this information on the internet, it was accurate, meaning they were not conspiring and giving false messaging to harm anyone. They were accurately putting out information because they truly felt that they were in danger by government overreach, by the government trying to provoke them, by the government trying to harm them, and they were sincerely afraid. Now, for the government to say we were unaware that that was been helpful to the defense when that's actually charged in the indictment makes no sense. Makes no sense. These are experienced prosecutors.
The AUSAs were not aware of the fund drive. That's the whole problem. Is this thing was hanging on a keychain someplace in somebody's trailer. It had never become part of any of the investigative files. So it wasn't like the AUSAs or the FBI thought, here it is, let's bury it in the back of some filing cabinet, hope nobody finds it.
Well, Your Honor, when the government was ordered to produce it, the only thing that needed to be done to produce it was to ask the TOC operator. The TOC operator looked in the TOC file. The TOC file was then produced, And when asked where it was, the TOC file was in its quote designated area in the TOC van. That's it.
Counsel, you're down to your last minute and a half, and I would still like to hear anything else you want to add to Judge Watford's question. So you told us the TOC log was important. Is there anything else? What's the next most critical piece of evidence that was withheld by the government?
The next most crucial piece is the threat assessments, because that was something that the government had in its possession the entire time. And the threat assessments were important because one of the arguments was that the BLM had been provoking the Bundys to react. And the 2012 threat assessment, which the government had the entire time, was withheld from the defense, even though they specifically asked for it, even though they denied to the district court that the defense had asked for it, even though they specifically said they made the conscious decision not to provide it to the defense. These are the types of misrepresentations that the district court found were flagrant, were willful, were egregious, were outrageous.
I want to give you a chance to respond to what I saw when I looked at those threat assessments. I can understand why you might have wanted them. When I looked at the request didn't look very specific. It asked for threat assessments, but it said all threat assessments. But if I'm the government, I'm thinking, well, threat assessments are something that you prepare in the moment. It wouldn't occur to me to come up, I'm not sure it would occur to me immediately that you would want threat assessments from some other non-incident from several years before. So if you had said, we want all threat assessments that were prepared after 2005, then the government clearly would have violated that. But if you just say, we just want all the threat assessments, I might be thinking, well, we have a threat assessment prepared for this time, this day. We'll give you all the ones that were prepared by the sheriff and the BLM and the FBI in connection with this incident, not in connection with something else at some other time. So threat assessments are pretty particular to a time and a place.
If I may, Your Honor, the request was all threat assessments for, quote, this case. So my response is twofold. This case, meaning the Bundy case, the 2014 threat assessment, specifically by the FBI, relied on the 2012 threat assessment. So the 2012 threat assessment was specifically incorporated into the 2014 threat assessment, so it should have been provided, number one. Number two, because the threat assessments that indicated the BLM was accused of provoking the Bundys, that was Brady. That should have been turned over because that was part of something that would have been useful in promoting the defense that the BLM provoked the Bundys, and by the over-militarization of the law enforcement personnel and the way that they surrounded the Bundy home and used the surveillance camera and were circling the home with snipers with rifles at night would have supported that. Judge Navarro very carefully and very reluctantly not only granted the mistrial, but found the government's actions in this case were egregious, flagrant, and required that this not happen again. And this is a rare case, and it's one that I hope won't be repeated. But in order for the government's obligations under Brady to be taken seriously, Judge Navarro made the decision that she made, and she did not abuse her discretion. She did not make clearly erroneous findings, and it should be upheld under her supervisory powers and under due process.
Okay, thank you very much. The government has to save some time as well.
I have several points that I want to make in response to opposing counsel's argument. First of all, on July 12th, 2017, that's 4 months before the trial, Ryan Payne filed a pleading in the district court. They include it in their supplemental excerpt of record, volume 14 at page 3157. And in that pleading, Ryan Payne tells the court that based on the discovery the government had already produced as of July, that discovery, quote, makes clear that the Bundy residence was being surveilled 24/7, unquote, and that their surveillance teams, quote, were equipped with, among other things, rifles at all times. So they knew in July 17, based on all of the material that we had already provided, that the Bundy residence was being surveilled 24/7, and the surveillance teams had rifles. And so when they stood up, same Ryan Payne's attorney, on November 3rd at a hearing and said, we just learned yesterday for the first time that there were actually officers overlooking the Bundy residence on a nightly basis carrying rifles. And that, I mean, I think that what happens is, they said it over and over again. Amon Bundy's attorney said it on the 13th. This is the very first time that we're learning that they were surveilling the Bundy home with rifles. For the first time we're learning this. For the first time we're learning this. And the fact is that we had provided that information. They had acknowledged that we had provided that information. And it is true, if we had anticipated this defense or this theory that those officers or that the surveillance camera could have been mistaken for a sniper, then when we did our first pass through, when we were turning over 400 FBI 302s, we would have turned over those as well. There was no reason not to. And I think at the end of the day, we get back to this idea of flagrancy. This isn't about whether the government missed a document here or fell short there. The question is whether this was flagrant misconduct. And for that, I think you actually have to look at what these documents were. There was not a single one of these documents that we withheld because we did not want the defense to have it, right? I mean, this is not a cooperation agreement of a testifying witness. This is not a rap sheet of a testifying witness. This is not material that if the government doesn't disclose and they know that they have, the court can sort of make an inference, whether as a factual matter is true or not. There's an inference that, you should have known that this is very clearly Brady. What we're talking about here is maps that were identical to maps that we had provided 18 months earlier. We're talking about the Felix Supplemental 302, which is the fifth piece of evidence for the uncontested fact that Rangers Brunk and Russell were on the Hill. I mean, for them to say that failing to disclose the Felix 302 because he said that he saw an officer on the Hill, when we've already turned over videotape of the officers on the Hill, emails from the two officers talking about how they were on the Hill. One of the officers testified at one of the early trials that he was on the Hill. I mean, there's simply no reason for us, other than simple inadvertence, to have not turned over that document. And when it comes to flagrancy, you have to find willfulness or reckless disregard. And if you look at the discovery log and the hundreds of hours, if not thousands of hours, that the prosecutors went through page by page, trying to give the defendants everything that they might be able to use, but sparing them the document dump that they have warned us against. I mean, Ahmed Bundy, in his pleading before the complex case conference, put the government on notice, saying, in the 10th Circuit, they say the government can throw a bunch of thousands of pages of irrelevant documents and then say, hey, look at all this discovery, we need more time. You better not be doing that. And so we were very diligent about that. So you can't get to reckless disregard of our constitutional obligations. And then the other one is willful disclosure, willful suppression. And here, yes, we didn't turn over these documents. Two of them were absolutely redundant to information that had already been provided. And that's the Rhodes versus Henry case that says Rhodes versus Henry says that's not a violation at all. And regardless of whether it's a violation at all, it's certainly not flagrant misconduct. With respect to the threat assessments, I think that the Coring case has a good analogy there, because in Coring, this court actually vacated defendant's conviction and sent it back for a new trial, didn't dismiss the indictment. But you went through each of the documents, and as Judge Watford said, I mean, you have to do that. At the end of the day, you look at them collectively, but you also have to look at them individually. And one of the documents that was suppressed in the Coring case was evidence that a government witness had said a year before the alleged crime, had said that he didn't think the defendant was corrupt. And so on appeal, the defendant said, well, I could have used that to cross-examine this witness, because he had said that he didn't think I was corrupt a year earlier. And what this court said is, even if that's admissible, and fine, okay, it's admissible, but we question the materiality of something that somebody said a year before the crime, assessing the defendant's character.
You're talking about another case, and you're over time. Is there anything you wish to say to sum up a sentence or two?
The only thing that I want to say is that at the end of the day, we do acknowledge that some of these documents certainly should have been turned over, and to the extent, based on what the court found, there was a very good chance that we fell short. But what we're talking about here is flagrant violations, willful, substantial prejudice, and here a new trial, or at most striking the 3 overt acts from the indictment would certainly cure any possible prejudice. So we'd ask this court to reverse.
Okay, thanks. We'll thank both sides for their argument. United States versus Bundy submitted. Our last case on the calendar this morning is United States versus Engel. You have both counsel ready for U.S. versus Engel?
Good morning, Your Honor. This is Warren Markowitz on behalf of Todd Engel.
And for the government?
Adam Flake, I'm ready, Your Honor.
Okay, when you're ready.
May we begin, Your Honor?
Mr. Markowitz, I can't see you. Are you supposed to be on video?
I'm sorry, Your Honor. I'm not able to be on video. I'm on a very bad internet connection, so I'm on telephone right now.
Okay, that's fine. Then I just want to make sure that we were hooked up in the way we were supposed to be.
Yes, sir. And I was informed by the support people to maintain a clock so I wouldn't run over because I can't see the timer.
Okay.
So I've set a timer for 15 minutes.
Perfect. And would you like to reserve some time for rebuttal?
I'm going to reserve the last 3 minutes for rebuttal if that's okay with the court.
And that's fine. And you try to keep track, and we'll try to help.
Thank you, Your Honor. If we may please the court, my name is Warren Markowitz. I am appellate counsel for Todd Engel. Mr. Engel is currently serving 168 months at USB Lompoc for his participation in the prior Bundy protests that this court just recently heard. Our appeal surrounds 3 specific issues that we'd like this court to address and to review. One is the imposition of standby counsel upon Engel as a structural defect in his Sixth Amendment rights. The second is the denial of a new trial motion based upon the dismissal issued by the court for the Tier 1 defendants in, I believe it will be trial 3, which would be the one, the case that was just recently heard by this court. And of course, a review and possibly dismissal of the imposition of financial obligations under restitution based upon an improper calculation of the matter for by the government. Beginning with the first one, the imposition of standby counsel as a structural error, the court effectively denied Mr. Engel his right to control and direct his trial as it saw fit. The action was taken sua sponte, that the appellant couldn't continue because the grounds for the revocation of his Sixth Amendment right to self-representation was based on the court's fear of a mistrial. The court conducted properly a Ferretta hearing. They reviewed the materials with Mr. Engel. They addressed the issues of whether or not he understood the procedures, what his education was, what his issues facing him were, what the potential downfalls were, what the benefits of proceeding with counsel would be, and he chose to move ahead without it. The court accepted that.
Counsel, can I focus you, this is Judge Watford, can I focus you on one specific aspect of this issue that you've raised, and it's this?
Yes, sir.
Ordinarily, I would be inclined to agree with your position that the mere asking of one improper question by someone who is representing themselves wouldn't on its own, under normal circumstances, be grounds for revocation of their right to represent themselves. But I guess in this instance, as I understand it, what especially concerned the court was that the very question that was posed was the subject of prior discussions between the court and I guess your client. And what I'm not clear on, I guess, is how specific was the court's direction to your client that he would not be permitted to get into the what was it, the criminal investigation of Agent Love? Was that what
I think, to be frank with the court, I'm not 100% certain on how deep and how broad the conversation went with him, outside of potentially saying, we discussed this, we're going to move forward with it. I think what the court should look at in this respect, and I think it's extremely important, is that one of the things that Ferretta doesn't stop on is the lack of judicial or legal experience that an individual will have, the lack of the education that a person has when it comes to legal matters and so forth.
Counsel,
it is quite possible.
Counsel, help me with the question I put to you, which is.
I'm trying to, Your Honor. Forgive me.
A second. Can you listen to my question, please?
Yes, sir.
I'm asking you to fill me in on the record. What does the record say about how specific the conversations prior to your client asking this question? How specific were the discussions that the court had with your client about what he was and was not permitted to do with respect to the question that he ultimately posed?
I apologize. I cannot specifically answer that question. I cannot direct it. I cannot direct a specific issue or a specific section for you. Okay. I apologize for that.
Okay, on the assumption that, and we can look back and read the record, on the assumption that it was quite clear to your client that this was that this question was not permitted, he nonetheless asks the question. He asks about the criminal investigation that he knew did not exist. On that assumption, was it improper to relieve him of his ability to represent himself for the rest of the afternoon?
Yes, I believe it was improper, Your Honor.
Because?
I believe it was improper because, again, the issue is there could have been, had Mr. Engel understood the ways around issues, bringing matters to the attention of the court for alternative purposes, not necessarily for the issue of which he was discovered or discussing. Also, there were opportunities, we raised this in a brief, that there really were a limited amount of constitutional issues in which a judge may remove a defendant from representing himself. I don't believe his action, this one particular question, wound up to be sufficient to be disruptive, where she had to silence him, short of saying no more questions here, admonish the jury. She actually went to the point during trial. The court actually went to the point and said, we're not even going to discuss this with the jury. I'm already doing review on this trial. I think the issue there is she was so afraid of what might happen. And it's respectable. This was a complicated matter. This is a complicated case. There were defendants who were split into 3 different groups because there were so many of them. But I think the issue should have been, if Mr. Engel was told, you need to sit down, chill, and have your standby counsel now take the place, it would have been necessary for the court itself to inform the jury why things were happening. That issue alone, to be shut up, sit down, and have the standby counsel placed in his position, who also challenged the court at that time about him being put in place. I think the prejudice there alone made him look like he was trying to wiggle out of something.
Now, let me ask you this. As I hear the argument you're now making, it sounds like a harmless error argument. That is to say, I think I just heard you say that if the judge had explained to the jury why she was having standby counsel do the work for the rest of the afternoon, that would have been okay. Is that right? Is that what you're saying?
Potentially. And the reason why I say potentially not, yes, under general circumstances, I would tend to agree with you, Your Honor. But under these particular circumstances, I don't think the harmless error standard would apply, because the issue involving standby counsel at the very beginning was that standby counsel was not there for the benefit of Mr. Engel for assistance, for review, for understanding, for direction, for support, but for the benefit of the court and the court alone. And the judge, when she appointed standby counsel, specifically made those statements to him.
Well, the reason I'm asking the question is that denial of self-representation, right, that's structural error. I mean,
yes, sir.
Deny the right or not. So I'm not sure why you're saying it would have been okay if the reason for her doing it was explained. Meaning it either was or was not a violation of his right to represent himself. And if it was a violation of that right, harmless error is irrelevant.
I believe the issue is structural. Under the circumstances you described, even if Mr. Engel was an attorney making the argument and he stepped over a line and the judge during a trial admonished him, that would be acceptable. On the other hand, in this instance, because he's representing himself, I think the vacuum that was created by him being removed so abruptly goes to the structural error, goes to the harm that was caused, because he was also not only denied the right to speak at that point to the jury or to the court, but everything that he wanted to do, therefore, had to be filtered through the standby counsel, which in effect denies him his right to manage his own trial, which is one of the Sixth Amendment, the cornerstones of the Sixth Amendment itself. And I think that's where the structural error becomes set in stone. I think that is the issue that we have, that this court should really concentrate on when it makes this decision.
Okay.
I see I'm almost at my 5-minute mark. I believe that this is the issue that I would like the court to concentrate on. The Brady material is, as far as I can understand and as far as I see, should be appointed and should be applied to Mr. Engel, but I believe that the Sixth Amendment violation here is the controlling one.
So does that mean you want to hear from the other side and then you save the rest of the time?
Yes, sir. Thank you, Your Honor.
May it please the court, Adam Flake for the United States. If I could start out by answering Judge Watford's question. I laid out in my brief on page 14 a little bit of the procedural history of the issue of impeaching Dan Love. What happened was, subsequent to the events in this case, Dan Love was the subject of an OIG investigation for things that he did the year after at Burning Man. And the defendants very much wanted that to be able to introduce that in trial, in keeping with their general trial strategy of making the BLM look bad. And so they filed a motion. They filed a motion asking for the OIG report, and there was some litigation over it. The government said that it was not going to call Dan Love. And when the government said that, the defendant subsequently filed a motion to be allowed to call Dan Love for the purpose of impeaching him for bringing up this to bring in the fact that he was subject to an OIG investigation. And also, I want to be clear, it was an OIG investigation. The claim that he was under criminal investigation, that was never talked about. That was out of left field. So there was litigation over whether the defense could put Love on the stand to make an issue out of this subsequent investigation, and the court ruled against them. Now, the court did not, I will concede, the court never specifically told Engel, you are not allowed to ask whether Love was under criminal investigation. It didn't think to, because that was out of left field. But it certainly made clear that Engel or no other defendant, neither Engel or any other defendant was going to be allowed to testify, to call Love to testify. And so that's as clear as it got. The judge, I'm not arguing that the judge specifically sat Engel down and said, hey, okay, you may not ask.
If Engel, the transcript after Engel asked the question certainly suggests that both the district court and the AUSA, who objected and called to the court's attention the problem, not only made the objection, but then objected and said, I think you ought to go farther and you ought to disqualify him from representing himself. certainly made it sound as though there was a direct order that Engel would have known of, that this was a very conscious, specific intent problem. And I think you've just told us correctly, because I looked for it. I couldn't find anything here in this record that suggested there's any kind of a direct order other than a refusal to allow the defendants to call Loves so that they could then impeach him with the thing. So given that we have a non-lawyer here who asks one question for which there's an objection that is sustained, how is this a proportional response under any of the cases dealing with Faretta rights?
Yeah.
Well, Your Honor, I think that the judge found that it was clear to Engel that that area was not allowed to be explored. And I think that under the circumstances, this court can defer to that finding because there was a great deal of litigation over Love. The court read the transcript.
Counsel, I know you're a very experienced AUSA. Has anybody in any trial that you've ever been involved in asked a question that they probably shouldn't have asked because the district court had told them not to? Doesn't that happen all the time, counsel? Yeah, it happens all the time. Of course it does.
Of course
that's an honest answer.
Your Honor left me very little choice. No, of course it does. But I think that the circumstances that made this case special were first of all, the length that the trial had gone on. We're 25 days in. The amount of litigation that had happened on the specific issue of Love, the total falsity of the question.
Why doesn't the district court just turn to the jury and say, ignore the question? I'm instructing you to ignore that evidence. It happens all the time.
I mean, I think the court would have been within its discretion to do so, but I want to emphasize that the finding the district court made here was based on her observation of how the trial played out. I admit that I was not there personally.
Okay. Counsel, in any of the Faretta cases where we've had people who have engaged in really serious misconduct, misbehaving, disrespect to the district court, and so on, where we've deprived them of their Faretta rights, do you know of any case in which somebody's Faretta rights were suspended rather than taken away? He was allowed to come back and be his own lawyer. It just was taken away from him temporarily.
No, Your Honor, I don't know of any case like that. And I wanted to make clear, because there was some discussion with opposing counsel. If this was error, it was structural error. Where the government is not arguing that it was somehow harmless. But the fact that the judge re-allowed him or reinstated him, I think goes to show that the judge took the revoking of his rights very seriously. She struggled with it. She found compelled to do it. There's something in the colloquy that followed the improper question where she says that she just doesn't feel like she could risk it. She said, Mr. Engel has made clear to me that he's not going to follow my orders. I'm not going to risk it. I'm not going to let him cause me.
Let me ask you about this question of risk. What was the threat, if there even was a threat, that if he were allowed to continue as counsel representing the rest of the evidence, then he would ask further questions, that he would disrupt, that he would do various things that the judge had some reasonable ground to believe would be the problem?
Well, Your Honor, I think the judge based its finding on her observation of him. She said, he's made clear to me that he's not going to follow my orders. I observed him I'm not quoting, but I observed him as he did this. He was very proud of himself for sliding that in. He was pleased with himself for being able to slide something by me.
No, I get all of that. This is a trial that's gone on for a very long time, as a number of defendants, and I would be quite sympathetic to an argument if it were borne out by the facts that there's all kinds of stuff that he might do that would jeopardize the case as to the entire case. Did you have any reason to think that were there other Love type questions that were lurking, and what were they?
I mean, I don't know about any future question. I can't imagine what other areas that didn't come out at trial. I can't guess at it. He did have.
The reason I'm focusing on this is you talked about risk. So what's the risk?
The risk, I guess, the judge found was. I mean, I don't guess. I think this is what she said. The judge found Mr. Engel has indicated to me that he is not going to obey my orders and that he would continue to engage in activity that would risk her needing to declare a mistrial. That was the risk she identified. She said, I find but sorry, was somebody talking? I can't hear very well.
But that's more specific if there's a risk of, there are two different things going on. There's risk of not obeying my orders. And the other one is risk of not obeying my orders, which produces a risk of a mistrial. That is to say, a risk that he's going to start asking questions, trying to get evidence in that is so prejudicial to the case that we're going to have a mistrial. And I'm having trouble seeing the risk that we're going to get a mistrial, even if there is further misbehavior. Can you help me on that?
Your Honor, I think that she was worried about the second risk. This case is, the panel is obviously aware.
About the second risk, there's the risk of mistrial. What was the warning?
I'm sorry, could Your Honor repeat the question? I can't hear very well.
I think that as a given that the district judge was worried about the risk of mistrial if Mr. Engel were allowed to continue to represent himself for the rest of the afternoon. But I'm trying to figure out, realistically, what is the risk of a mistrial? What was coming up in the afternoon where he might have done things that would produce a mistrial?
Your Honor, he had other, I think another witness did testify. He would have had another opportunity to cross-examine a witness.
And were there certain questions that he had been forbidden to ask of this witness?
Your Honor, I don't know the answer off the top. I'm not able to speculate about all of the various different ways that it could have gone wrong. I don't know of any particular issue. To be clear, I don't know that there was some issue lurking, but I'm not sure if the court knew that this issue was lurking either. I mean, the question about a criminal investigation had absolutely no basis in fact, but there it was sitting in the judge's lap, and she was forced to.
Can you just going back to the answer you started with, or the colloquy you started with, in terms of what's the most specific thing the judge said in that discussion before about the OIG investigation and all that? What's the most specific thing that she said that you think constitutes a direct order to Mr. Engel that he should have known this question is absolutely forbidden in additional
well, Your Honor, I think it's necessary to look at it in terms of what specifically the defense wanted to talk about, and the judge's response. And in the defense's motion, they specifically said, we want to get Love on the stand. We want to ask him about this OIG investigation to impeach him. And the judge, I can't off the top of my head quote the judge's exact wording in her ruling, but she said, no, you may not do that. You may not call Love to bring up this subsequent thing, the subsequent investigation. And so that's as specific as it was. She didn't go ahead and say, you may not also claim that he was under criminal investigation in your question or anything else.
Don't our cases ordinarily require the judge, before taking the fairly drastic step of revoking someone's right to represent them, for something like this, wouldn't the response normally be, objection sustained, at the next, Mr. Engel, I'm telling you, anything like that, you will not be permitted to. Isn't there some requirement ordinarily that you give the person some warning? Because as a layperson, how would you know that if I ask one improper question, it's game over?
Your Honor, there are cases that talk about that. The Illinois versus Allen case talks about, giving a warning. But I think those are more relevant to the sort of when defendants are engaged in bizarre antics and being disruptive and speaking out of turn and things like that, and they need to be told, hey, you're only allowed to talk when it's your turn to talk, and then a warning is appropriate. But in this circumstance where, you know, he certainly had been warned that he has to comply with the court's orders and the rules of evidence. That was part of the phoretic colloquy. But in this circumstance, where he does something that the court found that he knew he wasn't allowed to do, I don't think there's a rule that says a defendant gets one free shot at creating a mistrial.
This is not quite the same situation, but it strikes me as at least analogous. If Mr. Engel had been a lawyer representing a client and had asked an improper question, the district judge would, I expect, be quite unhappy. And the district judge might very well say, we're going to have a contempt hearing on this. But it would be very unusual for the district judge with one improper question to say, you are off of the case. And I can see that there's another lawyer willing to come in and do this, but you're gone. So if the normal response with an educated lawyer would probably be contempt, rather than saying you cannot do any, you cannot act as a lawyer or anything further, it strikes me as quite a severe sanction to do this to a layperson, to say, I'm depriving you of your constitutional right to represent yourself, when there's been no prior bad question, there's been no prior warning. If you ask a bad question, you're gone, and this advisory council is going to start to represent you.
Your Honor, to be honest with you, I don't actually know. I have not been involved in this. I have not been involved with a situation where a lawyer gets held in contempt for a bad question or kicked off a case or anything like that. But I think that just looking at the circumstances here, where the court is doing what she needs to do to control her courtroom and make sure that the trial proceeds without needing to declare a mistrial, I think that, I mean, it was certainly a harsh sanction, but the court felt like it was the appropriate prophylactic measure to make sure that Mr. Engel wasn't allowed to subvert the trial.
Okay. Any further questions from the bench? No? Thank you very much. And there's been some time, Mr. Markovitz, for done.
Thank you, Your Honors. It is, I think one of the issues that we should go back to, and I appreciate, Your Honor, you had mentioned the similar question I had brought up about whether or not an attorney would be the one who would get into trouble for such a circumstance. To add a little brevity, Mr. Flake, maybe you should try private practice, because I know one time or another, a lot of us get into trouble because of that, because we try to stretch the envelope as much as possible. In this instance, the fear of a mistrial has to come with the authorizations of a forever hearing. Knowing that we're putting somebody in play that does not have the experience, the education, the background, the understandings, and maybe even some basic law and order understanding, that a mistrial may be one of the things the judge needs to deal with. And to use that as an excuse to rip the right for him to run his own trial from him, I think goes back to the structural error issue. And I think, in my opinion, and in our briefs, I think we put that forward to the point where that's the matter that we'd like this court to address. And we believe that that's one is going to be result in this conviction being overturned. I'd like to present myself to the court for any other additional questions they may have, but I think I've made my points at this point. I don't wish to take any more time that's not necessary.
Any further questions from the bench?
No.
Thank both sides for their helpful arguments. The case of the United States versus Engel is now submitted, and that concludes our session for this morning. And we will now leave Las Vegas.
Your Honor, thank you very much for your time and your courtesy. Have a good day.
Thank you very much.
Thank both of you.
This court for this session stands adjourned.
Well, that was quite interesting. So much to say. I don't know, maybe me and Eric will come on and talk about some of the things that they try to do on there.